I have received a certain amount of interesting comments from people that have read the abstract. While it's realised that media on both sides of the Tasman routinely report the often, shall we say, substance-filled excesses of professional sportsmen, I wanted to just make some comments about privacy, how that relates to the reasonable expectation of privacy and how that impacts on high-profile sportsmen. Maybe a couple of comments about what it means by the public interest, and in doing so I was going to start with a small case study about a series of events that concentrate on the actions of the halfback for the All Blacks, a guy by the name of Aaron Smith, who is one of the most high-profile sportsmen in New Zealand. So all this transpired, or the whole thing occurred on the 18th of September 2016, which is a Sunday. The Saturday night previously, the All Blacks had played and beaten the Springboks from South Africa 41-13, and had assembled on the Sunday morning in their team kit, ready to get on an aeroplane to go to Argentina to play the next match in the championship series. Mr. Smith, it transpired, was seen a short while afterwards by a couple who had their young son with them, entering a, that's Mr. Smith, they were at Christchurch Airport. He was seen entering, I don't know how you describe it, disabled toilet, ambulatory toilet, one of the big ones, which is off a corridor in the airport concourse. He was seen entering this facility moments after an unidentified female person had also entered the same facility. And once they'd closed and locked the door, the husband of the couple then began recording on his mobile phone the so-called event from outside the closed door of this cubicle. Now, Mr. Smith and the woman were inside, if that's the correct term, for about 10 minutes, and the witnesses reported afterwards that they could hear rhythmic tapping noises coming from within the facility. Mr. Smith then left. The woman emerged a few seconds after that. Mr. Smith went back to where his teammates were congregated, got on the plane, went to Argentina, and the woman involved disappeared. It transpired, as this carries on, that the husband of the couple wasn't offended by the incident, but the wife later reported that she said the more she thought about it, the angrier she became. And eventually, some 10 days, 2 weeks after the incident, the couple approached the major daily newspaper in New Zealand and released their recording. Unhappily for Mr. Smith and the All Blacks, when this blew up in the press in New Zealand, they were actually in an aeroplane between Buenos Aires and Johannesburg, having beaten the Argentinians, because they were going to play South Africa next. Upon being made aware of the reports after landing in Johannesburg, Mr. Smith was asked by team management to give his version of events, and he denied having had sex with the woman in the toilet. Clearly something had happened, but as far as Mr. Smith is concerned, it wasn't that. Maybe he had been taking lessons from Bill Clinton. In any event, the widespread reporting of all of this caused no small amount of personal embarrassment to Mr. Smith. He requested to leave the team and go home, which he did, so he didn't play in the game against South Africa. Was waylaid by the press when he arrived back in New Zealand. He was later dropped from a media campaign which involved a new team strip. Part of the reason why the wife had got so upset was because he appeared on the Weet-Bix packet, which seems to be important in some way. And after that, Smith was further sanctioned with a one-match penalty for serious misconduct under the provisions of the collective bargaining agreement following a disciplinary hearing. We could have a long discussion about whether what he did amounts to serious misconduct, but we leave that for another day. Now, as it happens, the couple who reported this incident also suffered some pretty serious backlash, significant criticism in social media, on radio talkback shows, etc., which meant they declined eventually to release the video footage which they had of this incident, such as it was, and eventually said they regretted going to the media and at one point tried to offer Mr. Smith an apology, or so it was reported. Well, so far so good, or so bad, depending on what you think. As it happens, almost 1 year later, the woman involved, claiming, she said, that there was a misogynist culture and sexist attitude around rugby and that she'd been hounded on social media and in fact been defamed by the rugby union, which is an interesting claim, but we haven't got time to get into that one either. So she, or a friend of hers, or somebody else, released all the text messages that she'd apparently collected between her and Smith for reasons that are unclear, and it's not sure who actually released them. And from those, I don't know if you can see the date, that's really kind of the first one, the introductory one. You can see that that's dated 2014, which would seem to indicate that this relationship, such as it was between Mr. Smith and this woman, had been going on for some time, and they had been on what we could call dates in between. Interesting, because throughout this whole period, Mr. Smith is actually living with his long-term partner. Now, as part of it, you can see from those texts that the woman involved seemed to have been confused about the situation of Mr. Smith's relationship. It's not entirely clear how she could be confused, because as you can see, his icon on the text messages has both of them, and most of the time he gets photographed at All Black functions, he's with the same person. So it's not clear how she might have confused that. As it happened, of course, the tabloid newspapers, interestingly more on this side of the Tasman than on our side, seized on these events as they blew up a year later. You know, we get the typical vocabulary: sex romp, sordid, tryst, all the kinds of things you see in banner headlines. But whatever the circumstances, it was now pretty clear that what was being released indicated that Smith hadn't been entirely truthful, or at least been somewhat economical with the truth as to how all of this has transpired, particularly what he had told his employer. Now, again, you can see there's still an issue going on as to what the nature of the relationship is. It's different because it was you and because I didn't know you had an actual girlfriend. I thought you were just seeing someone. That adds a nuance to modern dating relationships that's kind of a bit of a mystery to me, but maybe somebody can help me work that one out later. Amongst the messages that turned up, what I've said is that you messaged me to come for a chat. I came for a chat. Nothing happened. But if anyone asks you something, please say that. I hope nothing comes out in the media. If you swear that we didn't have sex, then nothing will come out in the media. And one of my personal favourites, okay, are you will to do a sawn after Davided to say we didn't have sex in there? That's the phrase. I think it means, I'm pretty sure it means that, but I don't think predictive text actually gets you there. So what was now clear was that Smith had clearly sanitised his version of the events and had attempted to coerce her into making some sort of false statement, which she actually refused to do. And it transpired by this time, mostly in the British newspapers, because she'd been named in the British newspapers but wasn't named at home. She is apparently a lawyer, although she doesn't appear to have a current practising certificate in New Zealand, because she's not on the list of lawyers, and is a boxer of some renown, or an amateur boxer of some renown at Commonwealth Games and Olympic Games level. So after this all happened, then New Zealand Rugby, I guess appropriately, spent a lot of money on a new independent investigation, which concluded that while, at least it was reported, that it was concluded that while there were inconsistencies between Smith's statements and the information released, it was determined that that information didn't have any material impact on the sanction that was brought down. So he got no further punishment. It was indicated that he might want to be a bit more honest in disciplinary proceedings, which I guess an employer would want to suggest, and he got a final formal written warning on his employment contract. So that's the background. Now, I don't want to make any moral judgments, just want to investigate the issues raised by these events with regard to public figures and privacy and the public interest. So when we talk of invasion of privacy, we could probably define it as the publishing of private facts about someone who has a reasonable expectation of privacy in those facts, and where the disclosure might be considered highly offensive to the mythical reasonable person who would be in the shoes of that person. Now, that still means that there are defences of public interest, and if you obviously consent to the release of that information, then there would be no privacy in it. So we're talking about what we could consider to be the highly offensive or even just unwarranted and perhaps embarrassing disclosure of private facts. Now, those principles are a little more challenging when you're talking about a supposedly well-known person, given that we claim that we know more about them than you would know about the next person in the street. Now, in New Zealand, there's no current general right to privacy, although a similar one was released in the case Tucker and News Media ownership, circumstances being where a gravely ill complainant sought to prevent publication of details of previous convictions for indecency. Not directly relevant. There are some privacy principles in New Zealand contained variously in the Bill of Rights Act. The Privacy Act has 12 information privacy principles, and there are bits and pieces of a code of practice in the Broadcasting Act. Tucker and News Media was one of the first, as I said, where we look at can you prevent publication of this sort of information. A few years later in Bradley and Wingnut Films, the courts accepted that a tort of privacy did exist in New Zealand, but was still pretty embryonic. And what we get from this is that public privacy tends to hold the status of a value or an interest rather than a particular right. But the privacy interests of the person in the street are protected by the legislation in those specific areas that we just looked at. And in recent years, a general tort of invasion of privacy has really started to coalesce and develop. P&D might be the most instructive case in this regard. A public figure gained permanent suppression of any reference to the fact that he'd been treated in a psychiatric institution. So the High Court defined the elements of the tort of privacy as they are there. Public disclosure of facts, facts that are of private nature would be considered highly offensive, and that there was illegitimate public interest in those facts being released. Later, Hosking and Runting involves a celebrity couple. At least the husband thinks he's a celebrity. He's on TV and radio quite a bit. They unsuccessfully tried to prevent the publication of photographs of them and their children which had been taken in a shopping mall on the grounds that to do so would violate their privacy. It said unsuccessful, but by a bare majority of the Court of Appeal accepted that there was a tort of privacy in New Zealand and set out those principles, which are arguably pretty similar to the P&D ones. Existence of facts expected to be private, publicity given to those facts which will be considered offensive, but they also then went on to add that defence in that it had to be weighed against a legitimate public concern. The situation in Australia is rather similar. For those of you of a sporting bent, at least since Victoria Park Racing and Taylor, there's no recognised tort of invasion of privacy, and similar legislative protections at both state and federal level are in place. Slightly more complicated here because of the federal overlay, but you also have a similar Privacy Act that has 13 principles. The Broadcasting Services Act and the Telecommunications Act have things to say about privacy, and at state level there are sector-specific privacy legislation. There are also some particular criminal sanctions, but as there are also in New Zealand. That a tort of privacy might develop was left open by the High Court in Lena Game Meets, which concerned also an unsuccessful application to restrain the ABC from broadcasting illegally obtained footage of Lena Game Meets possum meat processing plant. They advanced part of that claim in the High Court on privacy grounds. They were unsuccessful, but the High Court at least indicated that they would be receptive in the future to arguments that a right of privacy could be recognised. 4 of the 6 judges suggested that if a new action for the invasion of privacy was to be developed, it should be limited, however, to the protection of a person and not a company. So it arguably relevant to our situation with Mr. Smith. In 2008, I think 2004, in Giller and Prokopets, the Victoria Supreme Court didn't positively find that a tort of invasion of privacy exists, but they also didn't refer to any other Australian cases which authoritatively ruled out the tort being in existence in the future. And 2 other lower courts had earlier held that such a cause of action was indeed part of the common law of Australia, which are those two there, Jane Doe and the ABC, and Gross and Purvis. Now in Gross and Purvis, the judgment went as far as listing what the court suggested should be the elements of the tort. A willed act by the defendant which intrudes upon privacy in a manner which would be considered offensive and which causes the plaintiff detriment in the form of mental, psychological or emotional harm or distress. I guess the only point I'd make about that is you'll note that the Australian list includes this harm element, which doesn't appear to be part of the New Zealand tort. So the US, the regime is different because we have the operation of the European Convention of Human Rights, which Article 8 lists a specific privacy outline. But the courts both in Australia and New Zealand have looked at some of these British cases and used some of the reasoning. The two most important are Douglas and Hello. Campbell in the Mirror Group newspapers concerns the model Naomi Campbell, who having made claims that she didn't use any drugs, was photographed early one morning exiting a Narcotics Anonymous meeting, which would seem to have contradicted her claims. But at least, although she was not entirely successful, that case established for the first time in English law that there was an actionable right for the wrongful disclosure of private information, including photography taken in a public place. As far as Naomi Campbell was concerned, we could also make comments about the fact that well-known persons generally seem to have a lesser right to privacy. So-called celebrities appear to relinquish much of their privacy purely by virtue of the fact that they're well-known, although becoming famous doesn't automatically presume a consent to loss of privacy. Certain figures that I'm sure we could all name crave and seek out attention, and in those circumstances they can't then turn around and get upset about adverse commentary, seeing as they've used the media to advance their own cause. But there's surely no type of public contract which says that in order to be famous you have to surrender your privacy. Now, to return to Mr. Smith, shall I return to Mr. Smith? It's not in dispute that he's a high-profile public figure, at least in New Zealand, although that's entirely through his exploits as an international sports person. For that fact alone, that is your exceptional ability to kick a football, it's not clear that all other aspects of your life should necessarily be open to public scrutiny. Now, whether a sports person famous for being a sports person should also then be considered a role model might also be open to debate. We could spend hours talking about that too, but won't right now. Although it's clear that advertisers don't wish to be associated with people who have a, let's say, bad public persona. Perhaps the best example of that is Tiger Woods, although it's clear in that example also that the level of morality can vary widely and be changeable. After Woods was outed as a serial adulterer, which sounds like a pretty pejorative description to begin with, some major companies terminated their sponsorship with him, Gillette and Gatorade amongst them, but other companies like Nike did not, so it's not entirely clear how this is supposed to play out. So wherever the boundaries are drawn, there remain areas of one's private life where we could assume that privacy endures no matter how famous you may or may not be. You might have seen in the papers just after Australia Day that a group of tradies in Sydney filmed and posted on social media a couple who were having sex in the afternoon in a high-rise apartment. The apartment was only viewable from across the road, similar high-rise where the boys were on their building site. Now, Section 91K of the New South Wales Crimes Act would indicate that filming a private act is an offence where, in circumstances where a reasonable person would ordinarily be expected to assume that this was being done in private. I don't want to go through all of the various bits and state stuff in Australia because they're all different, but it's Section 91K in New South Wales. In New Zealand, you're not allowed to, I might need a couple more minutes on that. In New Zealand, you're not allowed to photograph a person or video a person who has a reasonable expectation of privacy, if they believe they're in a private location, for example, and that no one is watching. So these things would seem to have similar effect. Now that principle was clearly outlined in Andrews in New Zealand, at least in New Zealand. That case involved the broadcast of detailed footage of a couple who were being extricated from a car wreck and were talking to each other. So the court determined that even though that was clearly in public, the expectation of privacy still covered the content of the conversations that they were having with each other. There was also a case similar to the Sydney one in New Zealand where a couple were filmed in an office across the road from a bar one night where they were also enjoying each other's company. Unfortunately for them, the treatment on the window meant that in the dark you could see through it, was actually set up to reflect the glare of lights. People in the bar stopped, the band stopped playing, they came out on the footpath and filmed it and also put it up on social media, which is also an offence in New Zealand. With regards, but the fact that someone, so therefore from that and from Andrews we can take the fact that something happens in public or is visible from a public place doesn't necessarily remove the expectation of privacy from the people involved. So as far as Mr. Smith's concerned, some suggested that there was no privacy breach as the pair was in a place that was readily accessible to the public. He was well known and they were doing things in the bathroom that you're not supposed to do in bathrooms. Perhaps Mr. Smith could logically claim a reasonable expectation of privacy because he went in and closed the door, locked it, and the whole idea of using something for unexpected purposes doesn't seem to hold water on the basis that our office couple in Christchurch were also doing things that you don't normally see in offices. In any case, an airport's may not necessarily be a public place. There are certain areas of airports that you can't go to, and the company that runs Christchurch Airport, even though they are publicly owned, have filming tariffs on their website, so you can't just automatically go in there and start filming. As I said, it's an offence to make an intimate visual recording of a person in New Zealand. 91K in New South Wales is a similar provision in the Queensland Criminal Code, which is section 227A. Clearly, you would hope that the people filming from the bar in Christchurch infringed that provision. The interpretation section earlier up in the Crimes Act in New Zealand certainly covers what they were doing. And in Australia, although it varies from state to state, there are similar prohibitions against this sort of activity. Note also that although they mostly had audio, conceptually the various parts of the Crimes Acts that states and in New Zealand indicate that you can't record a conversation that you're not a party to. Is effectively the conceptual area that they all kind of operate around. So therefore recording two other people doing something would appear to contravene that as well. Now we have this defence in common law, and it's included in some of the statutory provisions. It's in the public interest to release this information. We can probably agree that just because some members of the public are interested doesn't mean that the information or the release of it is in the public interest. And the existing jurisprudence would indicate that the public interest typically covers things like public health, safety, the conduct of the government, that sort of thing, as Mr. Joyce is finding out. But the sexual antics of even a high-profile sportsman would seem to fall kind of a long way outside those boundaries. And we can probably work out that no matter how distressed the couple at the airport actually were at the events, if the people behind the closed door had been an accountant or a truck driver or one of us, nothing would have happened at all. They probably wouldn't even have made a recording. So however unfortunate you might think the events of that morning in September were, it seems that the recording of well-known people or people who aren't well-known in circumstances that indicate at least some level of expectation of privacy, as well as the publication of that recording, can and probably should be sanctioned. And in the appropriate circumstances, that can include, as we've already seen, recordings that are made in public as well. So even if you consider an airport a public space, it doesn't necessarily follow that Mr. Smith's actions, whatever you think of them, automatically lose privacy status for that reason alone. And even if you put to one side the possible criminal sanctions that attach to the recordings made, it's not clear that publication of a sportsperson's tryst in whatever circumstances with an otherwise unknown person could be held to be in the public interest, no matter what your moral view on the matter is. So while Mr. Smith's employment shall we say, difficulties are a separate issue, and presumably employers generally don't want their employees rushing off to engage in this sort of activity while they're at work. The invasion of privacy issues that are raised by this type of incident are probably worthy of some reflection. Thank you.